Yeah, I think so.
And that's what's on.
Yeah.
It is, but also, well,
So anyway, breathe. We post anything. So anyone that's free.
how y'all doing back in? Good, good. Hey, you came in here and say good morning.
Good morning, everybody.
All right, ladies and gentlemen, let's go ahead and get started. Ms. Ogden, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Here.
Senator Stutz, Senator Weaver, and Senator Barfoot.
Here.
Got a quorum.
All right, we've got a quorum. First bill on the calendar, SB 30, Senator Singleton.
Mr. Chairman, as I spoke to you yesterday about this bill, this is a carryover bill, SB 30. I've been working with Alabama Office of Court, the AOC, and they're doing under their rules of judicial administration. They've come up with a set of rules that will affect this particular bill. I would like to carry this over indefinite, and they will bring these rules out, and I'm satisfied with the rules that they're going to bring out that will basically deal with this bill.
Okay.
And so the bill is not necessary, so they're taking care of it administratively.
Very well.
I appreciate you putting it back on the calendar. We can carry it over indefinitely.
All right, bill's carried over indefinitely. Appreciate you working with those folks, reaching out to them, and trying to get a solution to a real potential problem that's out there. Sometimes we see issues or concerns that people say are problems that are not really problems, and they're just looking for solutions. So thank you for working with those folks.
No problem, Mr. Chairman. Thank you so much.
All right, SB 30 is carried over. Next up is SB 174, Senator Coleman Madison.
Thank you, Mr. Chairman. This is the voting requiring notification to individuals who have lost their right to vote. We passed this out of the Senate twice. It was a larger version. And basically all we've done is just taken the part that we worked with Commissioner Ward on, and they have agreed, is that people don't have to apply anymore to for a certification to an application to have their voting rights restored, because quite frankly, most of them don't know whether they have met all the requirements of not paying fines or what have you, but the Partisan Parole does. And so basically what this does is eliminate that process. Once they have met that criteria, the board will post their names of the individuals that had their right to restored, and pursuant to the last county that they were registered in. Of course, now, it doesn't apply to people who were never registered. If you were never registered, you have to go through that process. But it does require them to notify the Secretary of State to let them know that they have met all the requirements for having their rights restored. And also, they will then notify the Board of Registrars of the county which they were last registered in. And basically, that's what this does. And then their names will be placed back on the polling rolls. But it just doesn't require them to make the application process, because Commissioner Ward said they already have and know who has met the requirements and who've not.
Mr. Chairman, the proper time move for favorable report.
We've got a motion for favorable in a second. Discussion on the bill. I did want to ask a question. I think you may have alluded to this already, but so the Board of Partisan Paroles has that ability in-house already.
Oh, yeah,
to notify those names. It's not extra work or extra burden on them.
No, we wanted to make sure. We worked with it, as you remember, we passed it already twice out of the Senate, but it was a much broader version of this. We just pared it down to basically, let's just get this part straightened out. They worked with us. They said it's not a problem. They already have the capability of doing that right now.
Okay. Members, got a motion for first and second. Any comments, questions, or concerns? Hearing none, Ms. Ogden, if you'll call the roll on that.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison,
Aye.
Senator Elliott,
Aye.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
And it's favorable.
All right, bill's given favorable report. Thank you, Senator Coleman Madison. Next up, Senator Gavan. It's SB 192, and I believe there's an amendment.
Oh, there's an amendment to the other one. I don't think there's one to this one.
Maybe I'm wrong.
This is the a bill that basically is carried by the Chair of Legislative Council each year, codifying what we did the previous year. We have
I move in favor report.
Yeah.
well, hang on. We have a. So this okay. So nobody told me about this one. What this bill does is it cleans up also each time some Scrivener's errors, and apparently this is another Scrivener's error. I have no knowledge. I didn't draft any of this stuff. So I would move. I think there's already been a motion for adoption of the amendment, so I'll second that.
You had a motion for adoption of the amendment and a second. Any discussion on the amendment?
What we've already done. Yeah, every year we pass this bill. The first 2 years it starts in the Senate, the second 2 years it starts in the House.
I know it's just that we never go back and check to find out what technical, so I'm just wondering, could we not pass something and give them the authority to clear up technical things? You know, you forgot to cross the T, people think it's an L.
When's the legislature ever given up power to do something?
All right, got a motion for first and second. Any other discussion on the amendment? Hearing none. Any opposition, use previous roll. Senator Stutz, you'd like to be added to that? Glad Senator Stutz, Senator Orr, like to be added to it. Motion to adopt the amendment is favorable. Back on the bill. Any further discussion on the bill as amended? We got a first and a second. Any opposition using previous roll? Hearing none, bill's given favorable report. Thanks, Senator Van. Next is SB 235. Let me get there, and I'm at a little bit of a disadvantage because I have looked and I don't have my glasses with me. So SB 235, if you'll remember here several years ago, 2-3 years ago, I had some concerns about juveniles between the ages of 16 and the day before they turned 18. There are two mechanisms for which a juvenile could wind up in adult court. One is an automatic transfer, and the other is that the juvenile court has a hearing and makes a determination whether that individual, that child, should be in adult court. No problem with the second part because you have some judicial overview about how that child gets to adult court. I had some concerns several years ago that a 16 or 17-year-old child, if he's charged with an enumerated offense, violent offense, could wind up in adult court and thereafter could be subject to the adult jurisdiction when the offense that he was charged with may have actually been a lesser included or something that he should not have been there ultimately. So you have this 16 or 17-year-old's name who's published for all eternity for the world to see without any judicial oversight. So the bill 3 years ago said that that individual, that child's name and information, identifying information, could not be released until or unless there was a conviction if it were an automatic transfer offense. Recently, there was a situation, and actually I think Senator Figure's district that got some headlines about a young lady who had, I think, either brought a gun or was shooting at school in your district. And there were some, the articles, you know, were, hey, we can't release the name because of this bill that had changed from a couple of years ago. Well, I started looking at that, and there's provisions in there which actually allowed the release of that information if it were in the interest of national security or public safety, were two of those exceptions. And it actually set up where I think the DA could have petitioned the court to release those names. I don't know if that was done or not, but regardless, that seemed to be a concern or an issue. So we looked at modifying it, and this bill would just be made public on an automatic transfer. So instead of waiting to the end, if there's a conviction, you would have a hearing ahead of time, early on in the process, for some judicial oversight, determination about whether or not the release of that information would be beneficial to the public. The DAs wouldn't necessarily have to request that. It would be a standard hearing. Senator Smithman.
Move favorable.
Thank you. Motion for favorable. I'll second that. Senator Weaver would be the second on that. Any, excuse me, we don't have an amendment on this one, I don't believe, do we? Okay. Any further discussion or any discussion on the bill? Hearing none, bill's given favorable report. Thank you, Senator Barfoot.
Nothing wrong with thanking you.
Nothing wrong with thanking yourself.
Dude.
All right, let's get on to SB 240. I'm also carrying that. Just a second.
Mr. Chairman.
Yes, sir.
At the proper time, I want to be recognized about this bill.
Yes, sir. Let me kind of give you a broad overview of what the bill does. You have an explanation in your packet there. The County Commission associations with probate judges and others have worked together to try to make a more streamlined process, a process which gets individuals the mental health that they need, and gives the probate court maybe expanded jurisdiction is not the right, but certainly jurisdiction of those individuals who primarily suffer from mental health issues on a commitment setting, but also may have a secondary diagnosis of substance abuse. So it's not an expansion from the standpoint that you can only have a substance abuse. You have to have a mental health illness and concurrent with a substance abuse that would fall into the purview of the judicial, the probate court. The second thing that the bill does is it allows, when a petition's filed, for instance, in Montgomery, and there's an individual who suffers from mental health illness, and they say move in the meantime or leave Montgomery County, for example, and go to a different county, it is quite cumbersome for the Sheriff's Department of one county to, the probate judge of one county to issue an order to mandate that that individual will be picked up in a different county where they have no jurisdiction. So those are two of the highlights included in here. Senator Smithman, you had some questions or comments.
I have some questions, Mr.
Yes, sir.
Chairman. This, so I won't forget it. I want to go backwards on my question. And the last thing you said, what did you just say about the probate judge and the order in the other county?
Yeah, let me.
Say that again. I got a question. That's secondary, and I just don't want to forget it once I ask the other question. What did you just say?
Let's call is Miss Hodge here? Lauren, you here, or Mr. Brassfield? Either one of y'all, if y'all want to, whoever wants to address it.
Oh, we got Senator Brassfield again. We done had Senator Brassfield for 42 years, y'all.
Why not Lauren?
He a good man, though.
Almost 42. Mr. Chairman.
Yes, sir. Go right ahead.
Senator, today, and this bill came from meetings this summer with the with sheriffs and the probate judges to try to make this process more effective. Y'all all know the mental health issues that we face in every county, and one of the things they talked about is exactly as the sponsor said, the petitions filed in one county, but before the issue can be resolved, oftentimes before there's a commitment bed available, the hearing's conducted. There's no bed for treatment. There's a bed that becomes available 3 weeks, 4 weeks, 5 weeks later. The person that's subject of the petition is no longer in County A, they're in County B, and the probate judge and the sheriff in the other county. We're trying to streamline that communication so that person can receive the treatment that they need.
Yes, sir. Go right ahead.
So if I want to just visualize this, so if we're in County A, that's where the hearing, termination, and everything. Now, presently, they moved to County B. County A order, because of jurisdiction purposes, can't really take the long arm right now and reach over there and say, okay, or well, literally order them. So you got to go to bed. This bed, that was part of the agreement, part of the court's order.
Right.
All right. So now you're making it where that order will move with them within the state of Alabama. You know, that's it.
Where the order, probate judge in County A can essentially hand the order off to probate judge in County B, and probate judge in County B can then ensure in the communication with the sheriff that that person is picked up and gets their treatment.
So are we saying that they have to give that order full faith and credit, or is it subjected for the other judge to go behind that to re-review it and then determine whether they're going to implement the order? Which one of those two are you trying to get us to do?
It gets the order in the hands of probate judge in County B. That judge then uses their discretion as to whether or not they're going to enforce it or not. The other judge is not required to, but it sets the transfer process where it can be handed off.
Right now the hand's tied. You can't do it.
Yes, sir.
Okay. All right, good. I got another question though for you.
Go right
Just
ahead.
a general question on this, and I don't really know who.
We do have an amendment, by the way, but I don't want to forget about that, so just somebody remind me. But go right ahead.
Okay, I will. I was looking at this, and it says that suffering from a substance abuse disorder secondary. What do we have a definition for that? And I'm gonna tell you why I said that, because we could call a substance abuse disorder if you taking too many Advils. I mean, really, you got. I know people who really have to. They're taking so many for whatever it is that they had to stop because of the liver problem that it'll cause. But still, that's a substance. I know the spirit. We talking about real stuff, hard stuff. But still, you understand as a lawyer that anything that's a substance can say that that gives me the right to grab them because you're abusing it. So is that something that...
There's the definition there. Look on page 5, line 140. Substance abuse disorder is a cluster of cognitive, behavioral, psychological symptoms indicating the individual continues using a substance despite significant substance-related problems such as impaired control, social impairment, risky behaviors, and pharmacological tolerance and withdrawal.
Does the substance have to be one that has been known or determined by the doctors to be I'm trying to use the right word, head on the tip of my tongue, one that's
like a controlled substance?
They can't break away from it. You know, with this, you stuck on it. You know what I'm saying?
Well, I think addicted. I think, in the probate hearings that I've been in, there's certainly testimony from experts about, what is, from the mental health standpoint, what's happening to this person. Are they a threat of harm to themselves or others? Is it a mental illness? In a confinement situation, is whether or not that person would benefit from treatment, and do they understand right from wrong? Will they get the treatment on their own? So I think that's a line of questioning that certainly, from a guardian ad litem standpoint, in a probate hearing, that person would ask those questions. If it is a substance abuse that's secondary, and that's the thing, because it's not the primary thing, you can't haul folks into probate court and say, well, I think this person should be committed because they have a substance abuse problem. It is a mental health problem with a secondary substance abuse problem. And I've seen that in the courtroom a lot of times where the court it may be an indication of the current law where it is, hey, yes, this person does have a mental illness, but we can't differentiate between the mental illness and the substance abuse. We know both of them are there, but we're not sure why this person is doing this. So I think this bill would allow probate judges to say, first of all, is the primary diagnosis a mental health issue? If there's expert testimony about that the judge believes is in fact a mental health issue, right, a mental health disease, and then if there's a secondary diagnosis, then their hands aren't tied. They're able to address that situation based on those facts. So.
One last thing is on the intent of substance abuse. Is do you know because so obviously you talk to people to do the bill, to do that. It's the fact that they don't take their medicine,
right,
is a substance abuse. I mean, you understand what I'm saying, because they gonna have some real behavior. They gonna fit the model for behavior because they're not taking their mental health medicine.
Right.
But is that considered an abuse that you can reach and get your hands on them? And I asked that question because I don't know, some of y'all may have heard me say it, but not for several, back in once upon a time in my life, I was a volunteer at the transitional home, and I'm talking about like a volunteer 2 and 3 days at the week where these people came out of Bryce and was there, and they, if they take their medicine. You know what I mean? Yeah, that y'all know what I'm saying. So I'm just asking, and I'm asking in a positive light because you can get your hands on them. Because otherwise, folks like in that case, what I did, like me, had to go in these abandoned houses and get these people and literally convince them to come on out of here and let's go back over here so we can get you tuned up. That's what I call it. So do you think it will allow them to be able to do that?
I think current law allows that if somebody suffers from only a mental illness under current law and that they're not taking their mental health medications and their actions are deemed that, hey, they're suffering from this mental illness, I think the current law already allows for that. I don't think this bill changes that because the substance abuse specifically says continues using a substance. It doesn't say is not using a substance.
Okay.
So, continues using a substance. So I think that's an important distinction there.
I move favorable.
Thank you.
You say you got an amendment. You say you got an amendment.
Got an amendment. Can I adopt the amendment first?
Whatever the chair wants to.
All right, and so the amendment you'll find in your package had some folks reach out to me, and I thought the same thing. Actually, I'll take a little credit for this. I actually thought the same thing before folks reached out to me. So this amendment, if you'll look, it replaces line 411 through 417. It basically does two things.
On page, which page?
I'm sorry, it's in your package. It should be right before the bill.
Okay. I don't have it.
Probably right after that first page.
Yeah.
I mean, you got something to ask about this amendment.
So the amendment basically does two things. It adds in circuit court. So part of the bill is, and we'll give you an example, if you're charged with a misdemeanor or a violation, for instance, disorderly conduct, and I use this quite often because you see folks who are charged with disorderly conduct and actually have some mental health issues, right? And so law enforcement a lot of times say, you know what, this person has a mental health issue. I believe that, but I've got to get them off the street. They're doing something wrong. They're doing something illegal. So valid charge of disorderly conduct because they're a threat to themselves or potentially others. So they take that individual and they book them into, say, the municipal court or the municipal jail. Well, they are really trying to help this person. So once that municipality or district court gets jurisdiction, right, then there's some controversy about should we give up jurisdiction to the probate court if a petition's filed, or can we give up that jurisdiction? The bill itself only had municipal and district court. There are certain situations where I think a circuit court more violation, and so we wanted to add in circuit court in those few and far between, I realize, but so that circuit, district, or municipal court could temporarily suspend their jurisdiction, hand it over to the probate court to address the mental health concerns. This is only on misdemeanors or violations. It's not on felonies. The second thing that the amendment did was the original bill had that the probate judge would file a petition, in that court, municipal, circuit, district court, to ask them by way of petition. I'm not aware of what the code says about a probate judge filing a petition, so this just clarifies that judge of probate who issued the commitment order may communicate with the judge or the district, municipal, or circuit court where they're confined to ask them to release. It just removes the petition language in there. It's just a communication between courts. So that's what the amendment does. Questions, comments, concerns on the amendment? Senator Stutz. Okay. All right. The motion for favorable on the amendment. Second, Senator Smitherman. Any opposition using previous rule? All right. Senator Carney would be added as a yes. Senator Albritton is a yes. The amendment is adopted. Back on the bill itself.
So move.
Got a motion, and Senator Stutz, question.
Thank you, Mr. Chairman. Does this apply only to adults or to juveniles?
Great question. It does not specify in there the juvenile court, although in Montgomery County, the circuit court is the juvenile court. We have 9 different circuit judges, 3 of which who handle juvenile cases. Good question, though. Okay. Maybe something to consider. I don't know that there's a specific answer to that, but we may need to think about that. And quite honestly, in my years of practice, and I don't know why, but I've had a juvenile in probate court on a mental health commitment, so I'm not even sure if the probate court, I don't know what jurisdiction the probate court even has over juveniles. That may be something that's addressed in the juvenile court.
Yeah.
Senator Smith?
I'm not through.
Sorry.
Got a comment about it that I think is not completely clear. As I thought through this of how it actually works, a lot of times someone may not be diagnosed with a mental health disorder, but their substance abuse leads to a psychotic break, and they present to the emergency room with psychosis with a positive drug screen, but they don't have an underlying diagnosis of mental illness. In other words, their marijuana use or their other drug use or whatever precipitated their psychosis. And so I'm a little concerned that the substance abuse disorder has to be secondary, because the quandary you get in is the chicken or the egg of which came first, where they have mental illness and started using drugs, or the drugs precipitated their mental illness break. And so it may be a little bit of a quandary, where it actually happens, of someone that doesn't actually have a firm diagnosis of mental illness. So I'm kind of thinking we maybe ought to say it shouldn't have to be a secondary diagnosis of substance abuse disorder. You could have a secondary diagnosis of mental illness from the substance abuse disorder. Either one could be first, in other words.
Yeah, and I think that's good questions, good points. I think ultimately, though, I think we don't want to expand the probate court's ability. This is my personal opinion. Either there's a mental health diagnosis or there's not. And the probate court's not looking at someone who, to your point, chicken or the egg, if they come in and they've been, I'm sure you've seen it in the hospital setting where there's a psychosis and maybe we don't know which one comes first, but the probate court has the ability under current law, and I think this law as well, to say this person suffers from a mental health illness, regardless of what it is, was brought about by substance abuse or substance abuse followed that mental health diagnosis. But as long as there is a mental health diagnosis, I think it covers the situations that you're talking about.
My question about the juvenile is, could parents commit a juvenile for substance abuse disorder treatment?
I don't know the answer to that. Lawyers?
No, I wasn't gonna try to answer that.
Okay.
I want to be recognized. I won't fool with that one because I don't know the answer to that one.
Great question. Let's see if we can get an answer to that, because I don't know under current law. Folks are shaking their head in the back. So juvenile court is the one who maintains jurisdiction over even mental health commitments. Okay. I knew I'd never seen a juvenile in my years of practice, so in the probate setting. So Senator Albritton and then Senator Smithman, he had his hand raised 5 minutes over there.
If he didn't have it, he the man.
Yeah.
We got both the men in here, so you go right on. I'll get right behind him.
Thank you, Mr. Chair. Thank you, Senator Smithman. A couple of questions. Thanks for bringing this. This is highlights some issues and significant difficulties sheriffs and probates and local are having. 2 questions or comments, if I might. Number one, can the probate finding of a substance abuse be used in a subsequent criminal action as evidence? That's number one. I don't know if it can or even should, but just that may give something there. I hope it does. But anyway, the second is this gives the probate judge the opportunity more latitude to be able to commit folks that are somewhat questionable. Is that correct?
I would think so, because I've seen in a courtroom where a judge says, hey, maybe they have a mental health issue, but we don't know if this is substance abuse or.
And the other part that comes into that is you mentioned experts, and in most of these probates, there's not experts. We have social workers that cannot diagnose it takes a lot of time to diagnose if there is an underlying, if there's not, or we don't have those expert witnesses. So this gives them some latitude in regard to that, which I appreciate. But what this doesn't do is the problem is where do you send them? We don't have a place to send them now. Even when we meet all the criteria, we have no place to send them. Thus, they go to county B, C, or D. This is a great concept and a great idea, but it doesn't solve the problem. We've got to have people that can diagnose, and we've got to have places to keep them, and we've got to have places that we can feed them, and we've got to have places that we can treat them, and we don't have that. So I applaud the efforts and the point on this, and this does give us greater latitude, but it doesn't solve our problem. That's my comment.
Yeah, and I think you're over the broad comment that we don't have places for them is absolutely true. I've seen that in probate hearings where family members may get upset because the judge has one of three things: to dismiss it, to continue it, or to commit them, and they will, a lot of times, more often than not, for whatever reason, continue it, and almost like a probation type setting where they're saying, hey, you need to take your medicine, need to work with these mental health providers. The fact of the matter is they get more treatment there than if we had bed space, because it's a reoccurring, hey, you get them in, you put them in a bed, and they may be only there for a week or so, and then they cut them loose, and that's the end of it.
More than likely what happens is they because the judge doesn't have the evidence to commit, they give the opportunity to the person or whatever to commit themselves. And the easy answer is, sure, I'll go into the crisis center. So they go to the crisis center, they stay overnight, they get a meal, and then they go home, because you can't hold them. A crisis center that we built several of does not fit this bill, does not fit what we need to have. But until we have the capacity to restrain, and that's what we're talking about here, is a restraint to control so that we can treat. This is a good idea and concept, but it's still not solving the issue.
I understand. Thank you. Senator Smithman, then Senator Pickers.
I think I had my hand up first. That's okay.
No, I had the hand up first. I know that part, but I'm going to yield to that. No, I had it first. I'm going to give it to her. Because I got recognized like that, but I yield.
Thank you, my sweet mate. S-U-I-T-E. We share the same office suite. Thank you, Mr. Chairman. Thank you, Senator Smitherman. I'm glad you brought that up, Senator Albritton, because we don't have the capacity. But we are the legislature, and we can solve that problem if we wanted to. You know, we can give all these tax breaks to different people, tax exemptions. We can give money from the Education Trust Fund to people who can already afford to send their children to private schools with the School Choice Act or whatever. And mental illness is at an all-time high, and it affects all of us. And I know most people have a mentally ill person in their family. And if you haven't, well, you know what I always say about that. We're all, got a little, we all have issues. Some of us are just better equipped to camouflage it, if you will. But when it gets on that level where a person has to be committed, and I've had to commit a family member before, so I know what that is like. But when a family doesn't have a place for their loved one, there are just so many different things that can happen, and it does present a problem for the community. So until we really acknowledge that problem and make a commitment to do something about it, it's going to continue to happen. And I don't think it's just an excuse to say we don't have the capacity. I think it's our duty and our obligation as legislators to resolve this problem. And I promise you, mental illness is not going to get any better. It's going to escalate just like the prison problem has. Thank you, Mr. Chairman.
I agree with you. Senator Smitherman and then Senator Grivan.
First, I want to go back to what you said. We're talking about the juveniles, and let me say this: we need to, we need to transform what you're doing right now over to juvenile court. We need to transform exactly because the segment of our society who is left out there hanging over the cliff is our young people. That's the whole thing that Representative Collins and I are working now, right this minute, to establish a criteria, in conjunction with the school board and everybody else, that's going to allow a certain level of due process. Young people they're left out in the cold in this. They don't have these processes from juvenile court to schools to anywhere. First thing that happens, and I applaud what you're trying to do, the concept. I'm telling you, it's got to go further. And I ain't telling you to take it further. I will put a bill in to take it further. If somebody wants the credit to do it, they can do it. But we've got to do that because you all heard me at that mic talk about a kid in school. First thing, just like Mr. Chairman said over there about the people not being able to determine. A teacher can't determine in school whether a kid got ADHD or whatever. And the first thing happened, I can tell you, after my own grandson, that's what I'm trying to tell you. First thing somebody cut up, write them up. That's prison to them. That's jail to them. This is just the kids, but it's jail when you put them out. It's jail when you write the record and suspend them because there's no determination. And I'm glad to see the path going in here that just cause somebody do something, that don't mean they guilty of the crime. That's what you're trying to say at the jail. I'm at the judges. Once you get there and they say, no, this person needs to be over here. We don't have nothing in place for kids like that. Nothing. They just out there. Okay, so that's the first thing. I just wanted to say that you're on the right path, and we need to do that. The second thing is what Mr. Chairman was saying over there. And I want y'all to listen at what I'm saying. Don't just take some comment on it. I want you to bear it in your mind as we move forward. Please quit passing all these bills that's got this great front end look, and we can't handle it on the back end. That's what he just said. That's what he said about that issue. Okay, but it's the same thing with all this school stuff that we doing. We passing all $90 million for math initiatives. We passing this and that, and we got 206 schools that are failing that we need to get money, five-figure money to each one of them to get out of failing to rise up. We rather spend $90 million for something to make us look good on the press, or editorial for math, the legislature did this, and leave 206 schools flunking. That don't make no sense. We pass bills and don't have the capacity to implement what we pass. Let's stop that. Let's get the capacity. And you say, what do you mean? You're going to hear this out of some, I know it. We're talking about that. And I want y'all to know, I got a bill in to give those kids, every one of those failing schools, the money. Now, first thing you're going to say, well, we can't appropriate the money because they don't have I know what, I've been here long enough to know what the comeback going to be. Well, they don't have clear what they're going to do with the money. No, get the money over there, and they'll get it clear. Because if they get it clear, and then we don't spend this money for all these programs, they can't get the money. See what I'm getting at now? See, so let's set up capacity to handle stuff that we're ultimately going to try to handle, and not handle it, walk on out of here, and then what we call it now, unfunded mandate. Ain't that what we call it? Unfunded mandate. Quit all these unfunded mandates and have the funds there when we have the mandate. Everybody with me on that? Everybody with me on that? I mean, because I'm serious. Now, this ain't no rant. I'm very serious that we need to do that. So I hope our whole attitude about these things first ask the question. And see, remember I tell you I'm a committee of the whole. See, I can't be on a float back there in the back in y'all meetings. I could if you invited me, but otherwise I ain't in there. So this way I got to get y'all to say it in there. You see what I mean? To each other. I can join the party.
Come on.
I'll just do this. I'll be an eye, and then I can go either way. but I'm serious when I say that, and that's why I made that comment in here, because we moving forward with the budgets. We moving forward with how we gonna spend money, and this money we cannot. I'm through when I say this. We cannot not take care of those 206 schools for the sake of. And in closing, I'm gonna say this: we talking about 206 million over here for schools that can rise up. And the governor and the High Hopes, ain't that a program where she gave the money raising the schools up? Was it the High Hope program or something like that? What she gave, about 15 million she gave schools around the state. Yeah, she gave 2 of our district, and our school rose up. They got out of there because they could hire tutors, they could hire programs, they could hire aides, they could have those students get individualized reading help, and all of that. It takes money. And we've got to do that for each and every one of those schools. So that's why I've said what I'm just saying, Mr. Chairman, is that was a good opportunity for us to realize that when y'all up there talking about that, we got to do that, because the program, somebody was saying that about the college program, that was Senator Figgins, when she just said that. You know, let's not forget, you know, the first thing you're going to hear somebody say that, oh, well, that was just $100 million. The bill said you can go up to $400 million. See, do that for the people who need it, and $206 million for folks we know that need it. Yeah. Okay, thank you, Mr. Chairman.
Thank you, Senator Smith. Senator Van.
Well, I appreciate the conversation that we've had here today. Appreciate you bringing the bill. I might take this opportunity to, you know, I love repurposing things. I hate things going to waste. And so I might take the opportunity to suggest that we could purchase and repurpose Judson College in Marion, Alabama, and take care of some of these needs for where to house folks like this.
Thank you. Any all right, any other questions, comments, concerns? Hearing none, any opposition using previous rule? Hearing none, bill's given favor report. Thank you. Good conversation. That's the reason I like this committee, honestly. SB 245, Senator Weaver.
Thank you, Mr. Chairman. The Alabama Crime Victims Compensation Commission hasn't been active in assisting human trafficking victims until recently, and they want to change their approach on how they take care of these victims. So this legislation would be the first step in them changing how they help these victims move forward and become whole again. It would provide that work loss would include the loss of income for victims of human trafficking, which has resulted from being exploited. So this change would then help these victims become whole again and establish independent living and a return to society outside of that criminal element. It also would allow for their commissioners to be in line with what other boards and commissions are doing.
I don't have a question.
Motion for favorable Senator Figures. Senator Smitherman's got a question.
What do you mean move in line with what the commission, what's moving in line? What's changing?
So sometimes they do things outside of their specific just board meeting, and it would allow
What kind of thing?
Well, that is, I was hoping that they would be there today. I would assume it would be working with the victims through working them back into independent living and helping them get back in line again.
When you said the loss of the income and that, how would they be compensated for the loss of that income?
So this does not increase their line item or their money in any way. It just allows.
I'm not against that either, but I'm just trying to find out what it is that will enhance the situation from the fact that they lost income, and is it any criteria to establish that they were getting income in the first place? You see where I'm coming from?
But they were being exploited. The people were providing for, their food and that sort of thing. And when you take somebody out of a situation like that, they don't have any income at all. So it just allows the Crime Victims Fund to be able to help them live independently without having to be dependent on any criminal activity.
Is it in the present criteria to establish as to how to determine how much each one of them should get or would get?
I know that they're working on that right now, and they felt like that they needed to change the legislation as the first step to being able to work on this whole strategic initiative of helping human.
Are we giving them the right versus us to promulgate rules that's going to establish what we just talking about that income, or is it going to be where they're going to have to come back to get an amendment to this statute that we going to pass? How is that determined?
I don't know the answer to that question, but I would assume that we would be responsible for helping them walk through those things.
Okay, now you gave me 3 assumptions and no answers. So will we be able to will I be able to get the answers to that before we vote on this on the floor?
And I had hoped, is there anyone from the Alabama Crime Victims Compensation Commission here? So.
No, I'm gonna vote and support, because I support anything we do in dealing with human trafficking. I just want to say that to you, but I just would like to know those answers. But that has nothing to do with my support for your bill.
Absolutely, and I can definitely get that for you. They are in Nashville today. They did not expect it to move so quickly. Our chairman has been very helpful with this bill, and they were not able to get back in time. I didn't know if anybody would be here or not, but thank you for your support.
Let me add this one, and I know Senator Figurs has got a comment.
Thank you.
Question. I just want to add this. I think the nexus, or my understanding of the benefit of this for those crime victims, or for those victims of human trafficking is to get them from where they're at to be able to kind of stand on their own, because once you're a victim, especially a victim for so long, and that's all you know, and your immediate needs are food, shelter, and you have nothing, it's really easy to turn back or to fall back into that same position without some help. So I think that's an important piece of this as well. Senator
They definitely have mental issues afterwards as well, depending on how much they've been abused. I just wanted to bring to light that this bill also increases the pay of the commission members. And I guess my question, they already get paid $250 per day and mileage for the attendance for the commission meetings, but they also, it's added on the last page, page 10, starting on line 263, all commission members shall also be paid an amount as determined by the commission, not to exceed $250 per day for each day spent in the performance of their duties. And I guess my question is, are there other commissions and boards that have this authority as well? I know that some of the boards get paid, to attend meetings, but when they're in their official capacity, performing their duties, do they get or have the authority to pay themselves again for each one of those days? And what would those duties be, and how long could it take? Because I'm sure they're going to vote to go up to $250 since they have that authority. So that needs to be addressed. That is a concern of mine.
Certainly, if you have that concern, to me, the important part is taking care of these victims.
I understand that, but this is part of the bill
If you don't like that part of the bill, bring me in.
No. But I just want understanding, Senator. I want to know what is so different about the duties that they will be performing, because I try to be consistent. And I want to be fair to all of the people who are serving on these boards and commission. And if this commission is singled out, I guess my question to the LSA is this the only board, or can we give this same authority to every board?
Mr. Chairman, once you get
to... But it would help me to know what those particular duties are when they're working on those days. So.
Senator Coleman Madison actually had her hand up.
Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman. I just want to follow up, because Senator Figurs is really on the same line that I was thinking, because I want to make sure that I understand. We understand the role and what they do in assisting the victims, and certainly we understand it, and Chairman really put it in a nutshell that if this is all you know, that's what you go back to. But I want to be sure and make this clear of what we're voting on as I understand it. The money, the additional money, is not, because the first thing I looked at, you really can't do a whole lot with the amount of money that is being appropriated. So this money is not for victims. This money is for an increase for the board, people who serve on the board. None of this money is going to go to assist the victims. So I just want to be perfectly clear about what we're voting on.
Senator Smithman.
Senator Weaver, I appreciate you giving that offer opportunity that you gave the senator figures about that part, because I didn't hear her response. So as a sweet mate, I'm gonna make the response. I will bring you in an amendment to remove that, and I'm gonna just tell you why. Number one is that's the purpose why we have the Sunset Committee. That's the purpose. That's what's got to come from them to us, for us when we, the changes, as you want to call it, to be submitted to us in the sunset bills. That it's not them automatically deciding themselves to do A, B, C, or D. And the second thing is this, and I said certain things because I want these folks to really hear it. If we ain't got enough trust in ourselves to give our own self raises and come in and cut out raises and whatever, I surely ain't interested in letting somebody else. I keep saying this. Where do we lose our individuality as citizens and whatever just because we are elected officials? We have this denial in our attitude that we don't need to do nothing, but we need to do it for everybody else. No, we need to do for us what we do for everybody else. If we don't make that automatic, you all need to figure out how we can go back to make that by the index with us. Because I ain't interested in giving nobody else what we don't give ourselves when we have the ability. Okay? I just want to say that to everybody in here. Because all you get is one day of a good editorial, and that's it. And you done took away a privilege or right or whatever just because we are citizens that we have. Yeah, and I want everybody to know that I ain't interested in letting nobody else automatically do something if we can't automatically do it for our own selves. And I ain't shy about it. I mean, hey, when the last time y'all went into the store, eggs used to be $1.89, now $3.69. Ain't them right? I'd go shopping, $3.69, $2 more. That's the cheap eggs. That's them look out in the little white carton. That ain't the cage or the organic eggs. So I'm saying, I want y'all to understand, I'm planting a seed in y'all minds that look, quit hitting our own selves over the head and then giving everybody else's roses. I mean, if you're going to give roses, we deserve roses too. If you ain't going to give roses, that's fine. So, no, I'm going to come with an amendment, just for that purpose. Because, no, they don't need to automatically do that. So and none of the rest of them agencies.
I'm happy to come work with both of you on that. Would you like to create a sub taking that part out, or do you want to
just to delete A, B, C, or D, that's all. Okay. No, I don't want to mess up none of that good stuff you got in there.
Okay.
Senators, any other questions?
Sir, I just wanted to say the reason I didn't respond with that, Senator, because I wanted to give Senator Weaver the benefit of the doubt to answer the questions. Because if it's something that this particular permission goes above and beyond doing their duties, then I just wanted to hear that answer.
Okay.
Thank you.
Certainly, I think the important part is taking care of the victims.
Okay.
All right. Any other questions or comments? Any opposition using previous role? Hearing none, bill's given favorable report. Next up is Senator Gavan, SB 255. Senator.
All right, thank you, Mr. Chairman. There is an amendment to this that is a friendly amendment. This is an agency bill from Pardons and Parole, and basically what it deals with is if in the state of an emergency, if they can't have the parole hearing in 20 business days, it extends it to 40, but it's only if there's a emergency, and this is just kind of reflecting back to what happened during the COVID time period. The amendment deals with, it changes on page 7, lines 170 through 174, that says if the parolee is being held in a DOC facility, the parole court shall be considered within 40 business days, or if the parolee is being held in a county jail, the sheriff may agree to it being considered within 40 days. And nobody can be held more than 40 days, but so basically this gives, the way I read it, it gives the sheriff the power to say, I've got the room or I don't have the room, and not have a DOC force somebody on them for another 20 days.
Question.
Senator Singleton.
So that goes beyond the 20 days if the hearing is not done in the 20 days as the original bill say.
Due to a state of emergency.
State of emergency, only in the state of emergency.
Correct.
But normally it would be the 20 days. If not
Correct.
20 days, then that person will be set free.
Correct.
Gotcha.
So I'd move for adoption of the amendment.
There's a second. I second that. Any opposition using previous rule on the amendment?
Question.
Yes, sir.
Who determines the state of emergency? The governor?
It's a health officer, isn't it?
Health officer?
Oh, yeah, well, the state health officer.
That is not funny.
And soon to be in well, I guess under the rule, it actually now, the rules that ADPH has adopted, it would require the governor's concurrence. So it will be the governor and the state health officer.
Gotcha. Okay, just want to make sure.
Any opposition use previous rule? Hearing none, amendments adopted. Any on the bill now? Senator Figures, did you want to?
Yes, is there anyone here from Pardons and Parole?
Let the committee know your name.
Hey, y'all, Griff Waller. I'm Government Affairs for Pardons and Paroles.
Okay, I know the problem that we've been having with paroles, and, you know, follow the rules and the policies or whatever, that they should be given that opportunity to parole. Otherwise, if people are not going to have that opportunity, we should just say everybody's going to stay in jail for life once they're convicted.
Sure.
It doesn't make any sense to me for us to have these different levels of offenses with the time there to serve, and then you've got a board that's going to re-sentence people to additional time. I, for one, believe that our Pardons and Parole Board needs to be revamped. It really deserves some serious looking into. So do you have the stats of how many people have been paroled?
I can pull the latest stats. I know that we've been trending up, or the board was trending up recently. There was a time that was much lower than usual, but I think over the past 3 or 4 weeks and even up to the past month that we're seeing significant progress and kind of increasing that to where it needs to be, about 30, 40%, maybe about 30%.
You know, and I understand the victims' families coming, wanting to do more, but if we're going to follow the law of the land, then that's what we need to do, rather than adhering to or giving more weight to that opposition of that person being given a parole. So I'd really like to see that. And the parole board members that are on this board, I understand, is it 1 or 2 of them are former prosecutors?
I think just one.
Just one.
Yeah.
That's the female that we just, right?
Chairman.
And she actually, when she was up for confirmation and she came to see me, she assured me that she would be fair, but I'm not so sure that she has been, thinking from a prosecutorial background. But I'd really like to see those numbers.
Yes, I know that we'll definitely get that for you, Senator. I know that Senator Singleton and a bunch of folks came to meet with the board, and we're going to pull some data. I talked to Senator Chambliss about that yesterday, and I'm following up with the 3 members of the board, and we'll get that to you all ASAP.
Okay. Thank you, Mr. Chairman.
Thank you. Any other questions, comments, concern on the bill as adopted, as amended? Any opposition using previous rule? Hearing none, bill is given favorable report. Next up is HB 75, Representative Insler. I know he was here earlier. He's a member of the Montgomery delegation. I told him I'd handle it, have a motion for favorable. I'll second that. Any questions?
One question.
Yes, sir.
Isn't mail carriers handled under federal law already?
It very well
Why
may.
we need this under state law?
Yeah, may very well be, but there could be concurrent jurisdiction if it's the United States Postal, which the definition is 32.6.380 is those persons employed by the United States Postal Service who is employed as letter carrier. So
Mr. Chair.
I believe that there is probably a federal statute that would already allow for that, but I think it's important to mimic that.
Now, I do understand that there are some private mail carriers, letter carriers that transport mail from one point to the next between post office that are under contract. Maybe this can help them also, I guess.
May very well be.
They're not federal employees.
Depending on how they're classified, you're at the federal level, you're right, this may include those folks because it does give the definition in 326380, so.
Okay, thank you.
Mr. Chairman, I'd like to
there's-
carry this over until Representative Ensler is here to answer some of my questions.
Okay, I certainly, we've got somebody from I see Postal Service in the back, I'm not telling you.
Actually, I'd like Representative Ensler.
I understand. I didn't know, you were standing up, I didn't know if you wanted to address the committee or not. And you don't have to, but if you wanted that opportunity, I see you're here, so.
Yes, Ortigas Felder, city letter carrier. I personally was attacked last year, April 25th, matter of fact. The federal government, most of the time, if it's not a big case, and they take over. But in my case, I ended up at city court for my assault, but it wasn't considered an assault. The person was just charged with harassment, and they reoffended someone else, worse than myself.
Can you tell us what actually happened?
They were on the do not deliver list, and they were upset that they were on the do not deliver list. So most people know around the time that their letter carrier comes, they went and saw me coming down the street and said, I got something for you because you're not going to bring me my mail today, and came out with the 2x4 and was swinging. I was spraying. The neighbors came out to get him away, and police came, arrested him. But because it wasn't any mail taken or firearm used, then the federal government was like, the postal inspectors were checks and things of that nature, major crimes. That when my case slipped down to that level. Right, because it wasn't a murder or
Yeah, right. You got to die first. I would think that a 2x4 is a weapon.
Yes,
for sure.
But we slipped through the cracks, so I decided to go into research when I found out that my injuries weren't sufficient enough to be considered assault, because I wondered why he was charged with harassment. So I did the research and found out about the criminal bill 13A and found out what was the definition of assault.
Yeah.
And I noticed that firefighters, waterworks, and everyone else were considered under that bill with any time they get attacked, no matter the injuries, that it would be considered assault. So I got with my representative, Ensler, and decided to present that to him. And yes, we do have a bill going before Congress, because I am the congressional liaison also for letter carriers. So we have a bill going through Congress, but all over the United States, attacks on letter carriers have been on the rise lately. As recently as like 2 months ago in Ohio, a letter carrier was shot and killed on his delivery route. So with our arrow keys and things of that nature, as far as identity thefts, the attacks on letter carriers have been on the rise lately.
Thank you. Now, just one other question, Senator. On a do not deliver list, is that the list that where you go into the post office and say, don't deliver my mail for a certain period of time?
No, that's the list that if a carrier is having a problem with a resident, we let our supervisors know, and we let the postal inspectors know. The postal inspectors goes out to speak with the resident, and they tell that resident, hey, stop what you're doing, you could be charged with federal crimes, Then they either do it or they don't. And then the next step, the postal inspector goes out again and they deem it a hazard. But again, you can't skip a whole street. So if you just don't go to, and I have a walking route, I don't drive around.
Right. And then they have they can pick up their mail at the post office.
Yes, they have to come pick up their mail from the post office.
Okay. Thank you. Well, I will remove my objection,
Yeah, I just want to know, so you actually hadn't delivered his mail, you just was coming down the street.
Correct.
But it was because he wasn't delivering to his house, because he was a harassment.
Correct.
Oh, my goodness.
Bless your heart. Well, praise God, you are fine.
Thank you.
I did. I did. I'll second.
Got a motion and a second. Thank you, Senator Figures. I do.
Thank you.
Representative Insler did come back up. I think all the questions have been answered at this point. So thank you for speedily coming back up. So
I'm sure he did way better than I could.
he did a great job.
He
That's
did.
for sure.
I mean, I'm sure.
Yep, did a great job. So any opposition using previous role?
No, sir.
Hearing none, bill's given favorable report. Thank you. And I thank you for coming up and for being here and for participating, because you had something happen to you. You let the person who represents you know that happened. Representative Insler was responsive to that and has worked diligently to try to get us to where we're at today. So thank both of y'all.
And if that bill in Congress is not successful, I'm sure my son Shamari Figures would definitely see it through.
Thank you.
With your vote. Thank you.
All right. Next bill up is HB 161, Representative Moore. I have not heard from Representative Moore. We'll carry that over. Anybody supposed to be in? Okay, Senator Carter.
I'm taking that one for him. I had approached him on the bill about a friendly amendment. I spoke to him last night and he agreed to it. So I'm going to go over the amendment real quick. What the bill is intending to do is to add the offense to existing law that if somebody creates a private image, currently this law deals with the distribution of an image without consent. What this does is address if somebody creates an image with AI or uses creation of, uses their voice. You've seen this technology where they use President Biden's voice, put it on a recording, send it out, even though that was not him communicating. So what this does is adds that to the current law. There was an amendment added in the House that addressed no internet service provider, search engine, cloud service provider. This is on page 3, line 82. Basically, those that provide access to the internet, they would not be held responsible. That was added in the House. What I've asked him to do is allow us to add an amendment. So like if a developer of the AI technology would not be held responsible just by solely having the technology. They didn't approve it or consent to what was being done, just like the internet provider didn't consent to them doing what they did. This just protects those developers of that technology if they are just solely providing. Now, if they intend to provide this technology for that reason, they are still liable, and he was in agreement with that and a request that we add that amendment to the bill.
So on the amendment, any discussion on the amendment itself? If not, I'll entertain a motion to, on the amendment. Got a motion by Senator Coleman Madison. Second by Senator Elliott. Any opposition using previous role? Hearing none, bill's amended. On the bill itself.
Okay. So, again, just a basic explanation is just adding the creation through AI technology of an image or the voiceover recording.
Move favorable report, Mr. Chairman.
Got a motion for favorable and a second by Senator Gavan. Any opposition using previous role on the bill as amended?
Thank you, Chairman.
Hearing none, bill's given favorable report. I think the last bill on the calendar today is HB 222 by Representative Underwood. I've told him that I would handle this for him today. I actually filed a similar bill, so we're moving his or attempting to move his. In essence, what this bill does is if you're an adult sex offender, you shall not accept or maintain employment in a volunteer position as a first responder. I think those issues have come up where those first responders are in a position of immediate contact with people and family in a difficult situation. I'd ask the committee to give the bill a favorable report and accept a motion on that.
Move favorable. Second.
Motion for favorable and a second. Any discussion on the bill as presented? Hearing none. Bill's given a favorable report. I believe that's the end of it for today. Thank y'all for hanging in there with us. We were a little bit long, but thank y'all so much.